Thank you, Director, for appearing today. I always feel the need to start my comments off with a little prefatory remark. I have the utmost respect for the ranking member here. We all want clean water. We all want clean air. We all want healthy kids. And I actually think that states are pretty good at this. I think my state, for example, Alaska, has the cleanest water, cleanest air, best managed fish and wildlife. Certainly in America, cleaner than California, cleaner than Delaware, cleaner than New Jersey. And it's state officials that do that. So we all want that. But we also, what's always surprising to me on this committee is that we also need agencies to follow the law. You have everybody from Lawrence Tribe saying burning the Constitution should not be part of our energy and environmental responsibilities. So in my view, and I have a lot of experience with SMACRA, in what we call SMACRA in Alaska, which is the state version of SMACRA. But this is classic Obama administration action, and you guys are all part of it. You can't pass a law, so you break a law with a regulation. The states that are impacted are almost 100% against it, which you will get sued on this one, trust me. And then you say it's driven by science, and I'm going to get into some of that, because with regard to Alaska, you didn't cite one scientific study that relates to my state, one of the biggest coal reserves in the country. When it's really a power grab in politics, thousands of new pages of regs, then there's this claim that it's partisan. Mr. Chairman, for the record, I'd like to submit the state of Alaska's letter from our governor, who's an independent, our lieutenant governor, who's a Democrat, who are fully opposed to this rule. So it's not partisan. The concern is federalism and the law. It's not the environment. We all want a clean environment. Again, my state has cleaner water and cleaner air than any state in the country. And it's not because you're helping, it's because state officials do it. So I think that there's no demonizing here. The problem is when a federal agency doesn't follow the law, it's our responsibility to make sure that doesn't happen. And what I'm always amazed about is how often my colleagues on the other side of the aisle say, it's fine, go ahead, violate a federal law, violate the Constitution. But Americans are starting to get really, really tired of it. So let me go into a couple things on process. You talked about the process. Alaska is one of the largest coal reserves in the country. Did you go to Alaska in terms of public hearings for this rule?
No, sir, we did not.
Okay, why? Did you go to any state west of the Mississippi?
Yes.
How many times? Once.
There was I believe it was twice. There was a hearing in St.
I believe
Louis,
it was once.
and there was also in Denver.
Come
on, Barbara, don't.
I don't want people to have.
Did you have any studies citing Alaska in your entire proposed rule?
Senator, if you look at what we were proposing to do—
Just answer the question. I have a bunch of questions.
I am attempting to answer that. Yes, the baseline data needs to be gathered everywhere. Just because we don't have baseline data does not necessarily mean that mining is not causing problems there. I've been across the country. I've seen water pollution in Colorado.
Hey, I'm sorry. You're not answering the question. Did you have any studies citing Alaska coal in your rule? No. The answer is no. So let me go on to another question. My governor had requested, again, he's an independent, that you did a 5-year rulemaking, thousands of pages, and you gave states 60 days to comment. Do you think that was fair?
Senator, they had over 100 days, over 3.5 months to review the documents, to provide comments, and we had extended the comment period as well.
No, initially you provided 60 days, isn't that right?
Initially, we provided a public comment period of 60 days.
You think that's fair?
And we extended it. I believe
3,000 pages, 5 years in the making, 60 days to comment. You think that's fair?
I believe it was, based on the quality of the comments that I've seen, that it's clear that the states were able to read that.
Let me ask another. I'm going to get a little more legal on you here. Section 101F of SMACRA. Do you know what Section 101F states?
Not off the top of my
Let me
head,
read
but
it to
I
you.
have it right
I do.
here, too.
So Section 101F of SMACRA states, quote, "The primary government responsibility for developing, authorizing, issuing, and enforcing regulations for surface mining and reclamation operations subject to this chapter shall rest with the states," unquote. You should be very familiar with that. SMACRA is a very interesting statute because a lot of statutes provide veto power of the federal government over state programs. But SMACRA specifically did not. The primacy of regulatory issuance and enforcement lies with, according to Section 101F, lies with which entity? You or the states?
As you indicated, the Surface Mining Act is very complicated. It imposes upon me the obligation to establish the minimum federal standards across the country.
Correct.
And under the section that you cited, it does give states that authority. Now, you need to go a little bit further because out of the 24 states that have primacy, about half of them have state laws that prohibit the state regulators from implementing rules that are more protective than the federal minimum standard.
So I just want to make it clear, for the record, SMACRA provides states, I just read it, 101F, the primary government responsibility on developing, authorizing, issuing, and implementing regs belongs with the states. And yet, you are making a rule that goes into essentially the ability to nullify. So let me get into that issue a little bit. Are you familiar with the letter that was sent to you by the state of Alaska on August 2nd, 2012? It was from the Department of Natural Resources. I was commissioner at the time. It was, let me describe it. It was OSM, who the state of Alaska had worked closely with for years, coming to the state of Alaska and saying, there's been a permit issued by the state for 20 years. We now want you to pull it. So the state of Alaska, when I was a commissioner, looked at the legal research, worked with West Virginia, and we politely told you to go pound sand, that you didn't have that authority. Do you think you have the authority to look at, permits that have been issued by states and retroactively nullify them? Is there anything remotely in SMACRA that gives you that authority?
Senator Sullivan, you are over your time. We had given you
Oh, I thought,
additional
Mr. Chairman, we were going to do 2 minutes after the...
Well, you've already used those.
Time flies.
May I ask one final question, Mr. Chairman? Just
Jay?
the D.C. Circuit said, quote...
I object unless you give that extra time to my friend over there. Is that all right?
Oh, I'd be glad to.
Well, it's up to my chairman.
Okay, without objection.
I just
So,
want that nullification question is a really important, and let me help you with it. The D.C. Circuit, talking about this issue in a 1981 decision, said administrative and judicial appeals of permit decisions are matters of state jurisdiction in which the Secretary of Interior plays no role. Your rule provides for the ability for the federal government to nullify state permitting decisions,
no,
and that's been clearly ruled by the courts and in the law to say you don't have that power. Can you just address that issue, nullification?
Thank you, Senator. If you look at the statute as a whole, what it provides that if states want to be the primary regulatory authority, they do so subject to the oversight of Office of Surface Mining Reclamation and Enforcement. That includes everything that they do under the law. And there is plenty of case law out there that upholds our ability to look at performance standards or after the fact whether a state regulatory authority made a mistake. And if you look at that statutory provision about that permit you're talking about, the law says that if the mining company fails to activate the mining within 3 years, the permit shall terminate.
all right. What we're going to do